Welcome everyone to the Lost Pines Groundwater Conservation District Board meeting. For today, it's Wednesday, January 15th. It is 3:30 p.m. Again, welcome to everyone. So with that, if we could all please stand for the Pledge of Allegiance and the Texas Pledge. Pledge allegiance to the flag of the United States of America, to the republic which stands one nation under God, indivisible, with liberty and justice for all. Under the Texas flag, the pledge allegiance to the Texas, under God, one indivisible. Thank you. Alrighty, so every January we have our elections. So that is the first thing up, item 1E on the agenda, discussion, consideration, and possible action on nomination and voting method for board officer elections for board action. So everyone should have received an email from Natasha, and there's hard copies with typical, the procedure that we've been using the last few years that I've been here at least. If anyone has any questions on the nomination procedure, now would be the time to ask any questions, or if not, if there's no questions, we could just move on to the actual election then.
Well, we would need to vote on the method.
On the method, so
If you want to adopt or have a motion to adopt the method that I recommended. Someone could do that.
Okay, it's based off of Robert's rules,
Right, so if you.
and we've used it last year at least. I
Right.
think.
So if you don't have prescribed bylaws that have a process, that typically you vote on the process and then you undertake the election after that.
Well, I would move to vote on the election method.
Second.
Okay, so motion to accept the election method as described by Natasha. And motion was made by Director Cole, seconded by Director Arsufi. All those in favor, please say aye.
Aye.
Any opposed? Right, hearing none, that motion passes, and then we will move on to the elections. Item 1F, pursuant to the board rule 2.1A, the board will conduct its annual election for president, vice president, and secretary treasurer for board action. So with that, I'll open it up for any motions or nominations, I should say.
I'd like to nominate our existing officers and vote on them as one slate. Second.
Okay, we have the nomination for the slate. We have a second, although I don't believe we need a second for the nomination, but thank you. Any other nominations? So this would be the nominating period. Not, then we'll actually then have the vote. So then we have a vote by roll call for the entire slate. So we're voting on the slate. Director Arsufi?
Yes.
Director Smith?
Yes.
Director Burgess?
Aye.
Director
Yes.
Exter? Director Phillips?
Yeah.
Director Semang?
Yes.
Director Cook?
Yes, sir.
Director Cole?
Yes.
And Director Rogers?
Yeah.
And I also vote yes. So it was unanimous, the nomination and the vote passes, I guess. And so the slate has been reelected for the year 2025. Alrighty, moving on, public comments. Anyone sign up for public comments? I don't see anybody here. Anyone online would like to open it up for public comments? Anyone online? All right, and no one here signed up? Nobody? Okay, so then we'll move to item 3 on the agenda. The consent agenda. Consent agenda items are routine and will be enacted by one motion. There will be no separate discussion or action on these items unless requested by a board director. Would anyone like to move anything out of the consent agenda? Okay, then I will entertain a motion regarding the consent agenda.
Okay.
Second.
All right, motion to approve the consent agenda by Director Phillips and seconded by Director Texter. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, the motion passes. Regular agenda item then, agenda item 4A, announcements. I do have, I guess, two announcements. One brought to my attention just now by General Manager Mr. Totten. There is an article in the Giddings Times dated Thursday, January 9th, 2025. And I have here page 5, and it says, Lost Pines, the title is Andy Weir, credited for the Lost Pines Groundwater Conservation District victory. So congratulations. I know, there was a lot of folks involved. A lot of lawyers, a lot of time, a lot of folks. There was many landowners involved, a lot of going up to the Capitol. And a lot of testifying and legal work. So to all those involved, congratulations, and Andy for being on, making it to the Giddings Times. Anyway, it's all good. And then the other announcement is I'd like for our legal counsel to provide a quick update on the Rambo permit process and where we are in terms of the status, like a quick status update. I think the board would probably like to know where we are.
Well, I'm happy to do it, but I noticed, and I didn't even notice he was sitting here when I walked in, that your board counsel is here on the Rambo permit. But as you know, when I was in the Florida Keys, you all voted to remand the matter back to Judge Abels. And so, we are currently in the process of working up the order that would send it back to the judge. And so in my opinion, I think all the parties would need to weigh in on that, but I'll let Greg advise on that as well, if he wants to. But essentially, there's nothing to do right now until we get that
So
order back.
an order is being drafted. It'll be reviewed by all the parties.
Right.
And then at some point when it's ready, I will sign that order.
Well, no, not quite. It would come back to the board,
Oh,
basically,
yeah.
consistent with your
Greg, would you like to
Yeah.
chime in? I'm not sure if that microphone's on, but you can tap on it and see if it's on. Nope. There should be a button on the top. Yeah, let Jim handle it.
Like,
There you go.
Yeah, need to make sure that the instructions to Judge Abel is very clear, because what it is before it's looking for. And so we want to make sure, that we have all of the parties involved in drafting up that order, so that they can say, at least they can sign up on the form of that order and make sure it reflects what you intend to have happen. So we will bring this back to the board for a vote again at the next board meeting, and then we'll go back to Judge Abel with whatever the instructions should be.
Okay, so the board gets another opportunity to review it one last time and make sure it captures everything.
I hope what we draft up reflects what you intended to have happen, but we want to make sure it's stated in a way that's very clear, so that things don't get derailed when they go back to Judge Abels.
Okay, thank you.
Do that.
All right, those are the only two announcements I had, unless anybody else. Okay, regular agenda item then 4B. We're going to have an update from the district council regarding district jurisdiction. And then you might as well, we'll do one at a time. So we'll deal with 4B, update from district council regarding district jurisdiction.
well, it's weird saying good afternoon. I think this is the first 3:30 meeting, but so like a lot of questions have come up either in public hearings or just public comments regarding kind of the scope of the district's jurisdiction. And so I wanted to quickly go over that. So the district also by statute is charged with educating the public about groundwater and also about, what it does. And the district does do that. Newspaper articles, newsletters, websites, social media, and I think most importantly in board meetings. But I'll take this opportunity to kind of go through like what's in and what's not in your jurisdictional boundaries and what you can do. So you have jurisdiction over essentially conducting, and this will get very like bulleted and scripted, but conducting aquifer monitoring and data collection. I mean, learning about the aquifers within your boundaries. Planning and determining the long-term desired future conditions. I won't get into what they are, but you all are aware. And so regulating production inside the district, and then, balancing aquifer protection and private property rights also within that regulation of the groundwater protection. Regulating the transport of groundwater. Impacts to other wells within the district from pumping, impacts to aquifers within the district, impacts to land surface or subsidence, which I'm reminded is not a significant issue here. I think there's a paper on that studying these two counties. Impacts to, and I almost like surface water resources. By statute, we are to consider impacts to the surface water resources. But that is impacts from pumping. So like water, if there's a water level decline in a surface water body, that would be within your jurisdiction if there's pumping, but not impacts to surface water quality. Also enforcing your rules and then also enforcing chapter 36. So you've got very broad jurisdictional authority, but there are some limits, and we can go over those, but essentially anything that's outside of 36 and your rules and kind of that high level that I just went over, the district, in the best of its ability, would refer those matters to like a local or state agency. So I'm going to go over some items that are not within your jurisdiction. I think in the Thomas Turfgrass public hearing, impacts to wildlife came up, and the Houston toad. And so, we don't have a jurisdiction over impacts to wildlife, but we can refer folks to, U.S. Fish and Wildlife or Texas Parks and Wildlife. Traffic. Sometimes Jim will get phone calls about, well, there's a lot of traffic on this road after you issued this permit. What are you going to do about that? Jim can't do anything about that. And so, those concerns, either county or local entity, whoever governs that road. Dust and particulate, that's TCQ. Stormwater runoff. We've heard folks come to you and ask for assistance with that. And that is TCQ as well. Let's see, soil quality, that is not within your jurisdiction. So if there's a concern about soil contamination, that could either be TCQ or, let's say it's an oil and gas issue, it would be the Railroad Commission. And so there are a myriad of other things that Jim hears every day that are not within our wheelhouse. But I think most importantly, kind of knowing the distinction between lately what we're hearing, surface water quality being within our jurisdiction versus surface water impacts would be important. And so TCQ, to protect surface water quality, they have a whole framework of authority delegated from the EPA, and they do that through a myriad of different permitting functions. One being, the discharge permits. And so, we don't get involved in that. I mean, unless we're protesting a discharge permit, this district has no jurisdiction over the actual issuance or the protection of water quality, surface water quality. Other things we've heard, light and noise, concrete batch plants, we don't do that here. So are there any questions?
Yeah, just clarification. I think you said, and I'm not sure you've listed so many things, surface impacts, for example, and soil contamination. What about contamination to recharge areas or to wetlands that seeps into the aquifers? And I know that's kind of a fine line, but things could pollute the aquifer, maybe not immediate. Is that TCQ? Or is it something we can consider?
So if it's within your boundaries and, it's so firmly back up.
Not the creeks or the rivers, but the
Right,
land.
yeah.
Uh-huh.
So if contamination of the aquifer is considered waste, and so waste is within your jurisdiction. If it is not, if there's no likelihood that the surface contamination is going to impact the groundwater, then it's not within your jurisdiction. So, I mean, it is fact-based, but I think generally, no, that would not be within it.
What about if a person uses that well that we're dropping lower and the water quality is so poor they can't use it anymore? That would be within our jurisdiction, wouldn't
Yeah,
it?
groundwater quality is
I mean,
within,
waste.
is always
So
within
even
our
though it's not
jurisdiction.
contaminated,
Right.
that's my point, it's naturally occurring. And so that's the difference, and
Right.
so I just wanted to make sure that we could address that if it
Yeah.
comes up.
Yeah, we can always address contaminated groundwater. We cannot
Or
address,
poor water quality.
or
Yeah.
poor water quality. We
Already.
can't do poor surface water quality. Yeah.
Thank you.
So another.
So you said that sometimes we get these misplaced complaints and we refer them on to county, state, federal, whatever. Do we refer the complaint on or do we refer the complainant on to go talk to that other agency?
Typically the complainant.
So we
So we wouldn't be
wouldn't
filing
to
a
take a
complaint
complaint,
anywhere.
send it on to TC.
Correct.
Could you talk that up for us so we don't forget?
Sure, I actually have it typed for once.
Okay.
Thank you. Okay, well, thank you.
Any questions? All right, next item up is item 4C, update from district council regarding the open meetings and public comments. Mr. Saleh.
Good afternoon, board. It's good to see everybody here again. I'm here to talk to y'all about everyone's favorite topic, public participation, public comments, and the Open Meetings Act. I wanted to start out by pointing out District Rule 15.8.A for public participation, which provides that all regular meetings of the Lost Pines Groundwater Conservation District will be called and conducted under the provisions of the Texas Open Meetings Act, Chapter 551 of the Government Code, which we'll be getting into here shortly. Members of the public are limited to observation of the meeting unless the board itself requests a member to address you all, or the person who wishes to address you submits a completed participation form to give comment during that meeting, and it's done so before the meeting. That form must list each agenda item that the person wishes to address, or any item that person would like the board to consider addressing at a future board meeting. As I mentioned, the district meetings are conducted under 551 of the Government Code, the Texas Open Meetings Act, which we'll talk about now. Section 551.041, as we all know, requires notice for the board to take place. That notice must include the date, hour, place, and importantly, the subject of the meeting, what we're going to be going over, what's on the agenda, and what's going to be happening. So public testimony, otherwise known as public comment, which is found in 551.007, as a governmental body, such as yourself as this board, y'all shall allow each member of the public to address yourselves regarding an item on an agenda for an open meeting and body. Allowing an individual to address the board regarding an item at the meeting before, they can do so either before, during the public comment section, or when that item is called. Importantly, this is for items on an agenda, again, and thus items that have been properly noticed. So you can allow them to address you on the item either during public comment, as I mentioned, or when that item is called at your own discretion. 551.042 regards inquiries made during a meeting. If at a board meeting, a member of the public or the board inquires about a subject for which notice has not been given to be discussed at the meeting, the notice requirements do not apply.
Wait a minute. What?
it states, if at a board meeting, a member of the public or the board inquires about a subject for which notice has not been given or to be discussed at that meeting, these notice requirements do not apply to, there are two situations where notice does not apply. A statement of specific factual information given in response. Let's say someone comes up and asks about something that's not been noticed or not listed in the agenda. Your responses are limited to a specific factual answer about what they've inquired or a recitation of existing policy in response to such inquiry. So let's talk about an example of that. Let's say during the public comment period, someone comes up and addresses the board and asks a question about a subject that was not in the notice for that meeting and is not on that agenda. They ask about a permit application that hasn't been noticed. The only response that the board may give to such an inquiry is a factual response. So for example, if they said, hey, where this permit application that wasn't noticed and isn't in the agenda, what's the status of it? And let's say the board or Jim would say factually, it's under technical review currently. Or if they come up and ask about, let's say, what is your litigation policy? And you can point to a specific policy, you can then recite that. Any deliberating, asking questions about an item that hasn't been noticed and isn't on the agenda, or promises to look into such matters are not permitted and are against the Open Meetings Act. Let's see.
So for example, like last month, we had the Lee County Commissioner talk about a waste treatment plant. We couldn't really engage him at that time. That was not, it would not be appropriate for us to actually start talking about that topic because it wasn't on the agenda. So we really can't engage him at that time.
Exactly.
Correct.
Outside of those two things, there's one other option that can take place, and that would be to propose to have that subject on the agenda in a future meeting. And then we can talk about it.
So it's okay to make an announcement about something not on the agenda, but we can't then have a
Engage.
conversation about it.
Exactly.
Right.
Exactly.
So Bobby, like, I did ask the judge what the name of the company was. Was that inappropriate?
I don't think, what questions and answers are not supposed to be taking place
Yeah.
on those
well, I
kinds of
didn't
things. Yes,
know.
ma'am.
Okay.
And I realized that I also told
Yeah.
the county judge, hey, we'll have
Yeah.
Jim look into it.
Right.
And from what you
Right.
said, that was not appropriate
Right.
either.
We just aren't thinking.
Exactly. We can say, hey, we can put that
Put
on a future agenda.
is the best
Exactly.
we can do.
And what's the penalty for?
I can look back into it, but might be
Do not.
Yeah. He knows the penalty.
I think it might be a Class B misdemeanor, but don't hold me to it. I'll look at it.
You don't have to.
All right. I'm almost done, I promise.
Yeah.
I'm gonna talk about closed meetings. Finish my little presentation here, or as we know it as executive session. That's found in the Government Code 551.071. And that allows you as a board to consult privately in a closed meeting regarding pending or contemplated litigation, settlement offers, personnel matters, or to deliberate the purchase or sale of real property. And that closed meeting is so that you can consult with your attorney, and it invokes the attorney-client privilege, which protects the confidentiality of those communications between the client and your attorneys. Purpose of which, of course, is to encourage open communication between client and attorney. However, there are risks involved with waiving the attorney-client privilege, and that can happen if, for example, privileged matters which are discussed are disclosed to someone who wasn't a party of said closed meeting. And therefore, it is imperative to not share items that take place in a closed session with people who were not subject to that closed meeting. And also, that's also a violation of the Open Meetings Act. Finally, while we know that final action on an item can only be taken during open session, any action taken in violation of Chapter 551 is voidable. So violating this act can result in whatever action that was taken may be voided. Thank you. That concludes my presentation. If y'all have any more questions.
How the committee? They follow the same rules or they? We don't have a full.
Have open meetings, but because if our committees had
Yeah,
open
they have
meetings, so we'd have to
small
post notice. Telling the public they could come, which
Well, that's
Post Oak, Post Oak has all of their meetings open.
If you have a
Things
quorum
that are choice.
attending the committee
Yes,
meeting,
it's a
you would
choice.
have to publish notice of open meeting.
But it's a choice, whether the committee meetings are open with an agenda or
Yes,
not.
that's right.
Okay, as a board, as a closed meeting, we can invite people to that meeting if there's a subject. For instance, we have Mr. Totten, we have a lawyer. After we're finished discussing matters, we can excuse Mr. Totten, and if we wanted to, we could excuse the attorneys. Is that correct?
That's correct.
Okay, thank you.
Good to know.
Well,
Well, unless it's, if, depends on the exception you're in on. If you're in on consultation with the attorney.
Right.
You can't kick us out. I know as much as you want to.
Once employees go, that is
Yeah,
absolutely spot
yeah.
on.
So do you have to write the notice in the agenda differently? Or if that were to be the case?
We do notice for executive session, if you think about other
So it's
items,
consult-
it'll say which exceptions we'll be relying on. And sometimes there's more than one. Could be consultation with attorney and real estate transaction. And employment matter. So, but yes, you can have non-board directors in there if they are necessary for.
If it's pertinent, but
It's
just for
pertinent
that
to the-
subject.
yeah, I remember we had the real estate agent.
Yes, we
One
did.
time.
We've had the.
We had the real estate agent,
Yeah.
for example, when we were talking about real estate. Any other questions?
Thank you.
Righty, moving on to regular agenda item number 4D. Discussion, consideration, and possible action on a resolution regarding draft legislation to amend the Texas Water Code, Chapter 36, groundwater conservation districts related to the deadline for a groundwater conservation district to act upon a motion for rehearing. Who would like to speak on this? Would be Greg? Okay. I believe you have a draft bill, if I remember. You have a draft. bill? Yeah,
It is in the-
it's in the packet.
What's happened is that the law directing how railroad conservation districts handle motion for hearing is different than the law addressing how state agencies address those same motions when the Administrative Procedures Act. Reason for that is because state agencies meet sometimes weekly or weekly, and the railroad conservation districts occasionally only meet quarterly. So, when we put in a deadline for handling a motion for rehearing, we gave the groundwater conservation districts 90 days to consider that, to advance that quarterly meeting process. Although technically it would have been probably 100 or 110, but properly address that quarterly meeting schedule. The court has interpreted Chapter 36 to say, and this is talking about the local district court and the third court of appeals, to say that if there has been a contested case hearing that went through the State Office of Administrative Hearings, then the Administrative Procedures Act applies, and therefore the motion for rehearing deadline is 45 days, not 90 days.
55.
55 days, not 90 days. And so that has messed up people who are trying to file an appeal of a district action. If the, for example, we had a hearing just now from Judge Abel's motion for rehearing based on his action would be 90 days before it be denied by breaking the law. If goes to SOA, that completely changes. I don't think that was the intent when we put that into water code. And the easiest way to handle this is to change the water code to match the same deadline as is in the Administrative Procedures Act. Now, districts have the ability to meet whatever they need. You have your regular meetings, which are whatever you have, regular scheduled meetings, your monthly, your bi-monthly, your quarterly, whatever they happen to be. You can have a special meeting in 3 days notice. So if somebody has filed a motion for hearing, is coming up on that 45 or 55 day deadline, then you can call a meeting to address that motion for hearing. So my recommendation is that the legislature consider changing chapter 36 to match the Administrative Procedures Act. And that will give the parties to these contested case hearings clarity on exactly when they're supposed to file their motion for hearing, because the numbers will make, we'll always have that problem. That would be, with that notice not yet been filed, we're just asking whether or not this board would like to take a position on whether or not that notice should.
Makes sense to me that things should be uniform, and consistent. Um, And, so any questions for Mr. Ellis on this particular, again, the bill hasn't been entered yet, so there's no bill number yet.
That's correct.
But,
You all approve it, when all these ratified sponsors, everything, it's on the file that bill.
Makes sense.
Yeah, that's.
yeah, I'll entertain a motion then we have a resolution that was in your packet. And so I'll entertain a motion regarding that.
So moved. Second.
Okay, we have a motion by Director Semang and seconded by Director Texter to, I guess, accept that resolution, or what would be the proper terminology? Adopt the resolution as in our packet. Thank you. All those in favor, please say aye. Aye. Any opposed? Hearing none, the motion passes. Thank you, Greg. Next up is item 4E, discussion, consideration, and possible action on a resolution regarding legislation to amend Texas Water Code, Chapter 36, Groundwater Conservation Districts, House Bill number 1690, related to an application for a permit for the transfer of groundwater out of the Groundwater Conservation District, and House Bill 1689, related to the use of certain groundwater export fees collected by a groundwater conservation district. So we have two bills that were in our packet, and the associated resolution was also in your packet. Will you also speak on this, Mr. Ellis?
This bill has already been filed. It is pending for legislation right now. And so we're just asking the board to show support for the legislation that filed it. And if you can support this concept, then please adopt the resolution in support of it.
And these were filed by our representative, Stan Gervis.
Okay. We can still comment on the bill after we after we adopt the resolution. Thank you.
We asked my comments before, does it matter?
They go through the same process for adopting legislation that we follow with adopting new rules. So that will be in hearings of both the House and the Senate on the bill. You can go to comment at those hearings. You can go to comment to the committee members prior to or after those hearings. And of course, when it comes up to the floor, you can comment on to the entire legislature as whether or not those can be passed or amended or whatever you want to say. So, and part of what I have to do as your representative in Austin is I have to watch and see what's happening to that bill as it moves through the process. The most dangerous thing in the world is a House bill that is a Senate floor amendment. The Senate floor amendment can say anything under the sun, and frequently does. So we're going to have to keep track and see what's happening. And then if we take action on some amendment that's been added to the bill after we have said we approve this bill, we don't want to have our name on the bill that's had an obnoxious amendment put onto it later on. So I'll be letting you know as things move through the process, and I assume we're going to have be the governance committee that I deal with on legislative matters, because we may need to meet with an hour's notice to say, we have this amendment and I need to find out what you think about it so I can communicate that back to the folks.
I just have a quick question then. Number one, maintaining operability of wells, would that include water that became really poor quality because it was a deeper well that had to be put in?
It doesn't matter why it's not operable. It's not a full or freshwater well. As of the operation of the other wells, then we could mitigate that well.
So the bottom line, what I heard is that there will be opportunities to change the bill if appropriate, if we believe that we would like it to see a change, there's definitely opportunities to tweak and change the bill.
Remember, most legislation that gets filed is fixing a problem we found last session. So, no matter what we get done or what we get passed, as we see it being read and interpreted by judges, we need to come back and say that's not what we meant.
And Greg, just to clarify, the resolution will be in support of the bill as currently drafted. This is not a forever lock where we're saying we're good. So,
Exactly.
Right.
Exactly.
And that resolution doesn't really get into any glowing show of support. It basically says Representative Gertis has had our back, we have his back, and that's it.
Okay, so the way the resolution reads, it says it's Representative Gertis filed multiple bills aimed at the purpose of the groundwater conservation districts. Is singular purpose right, or is there purposes, or is that the right term of art?
You were an English teacher at one point, weren't you? No? Maybe, or a minor in English? Okay.
I took English class.
We will add your S.
I consider myself something of a grammar Nazi,
Yeah.
and I still use Grammarly, and it routinely corrects me, so grammar's not that easy.
Any other questions from Mr. Ellis?
I would make a motion to adopt a resolution in support of House Bill 1689 and 1690 with that S put in it.
I second.
Okay, we have a motion by Director Cole, and a second by Director Rogers. All those in favor, please say aye. Aye. Any opposed? Hearing none, the motion passes. The resolution is adopted. Item 4F, discussion, consideration, and possible action on a resolution regarding legislation to amend the Texas Water Code, Chapter 27, injection wells, House Bill number 1523, related to a prohibition on the authorization by the Texas Commission on Environmental Quality of the use of a Class 5 injection well for certain aquifer storage and recovery projects. Mr. Ellis, that was a mouthful, on House Bill 1523.
This is another bill that's been filed by Representative Woods. It is aimed at aquifer storage and recovery projects. Generally speaking, local conservation districts across the state support aquifer storage. I think they're a good idea. So recharge projects, if they're done in the right place and done correctly. Unfortunately, the legislature has seemed to remove groundwater conservation districts from the process. Now, it makes sense for TCEQ to issue the injection well permit because that's what they do. They issue all permits for all types of injection wells, class 1, class 5. In this instance, however, they also set up how much can be withdrawn later. And in that, my opinion, that encroaches upon the duty of the groundwater conservation district. In addition, although the law states that the water being injected has to be drinking water quality and meet all those standards, it doesn't address potential chemical reactions that occur once the water goes into the aquifer. And I'll give you a perfect example of that. In Texas City, in the Gulf Coast aquifer, they were attempting to do an aquifer storage recovery project, surface water from Gulf Coast water. So they were treating that up to drinking water quality, injecting it into the Gulf Coast aquifer, and then creating a bubble of pressure, if you will, and then wanting to withdraw that later for use. Well, the oxygenated surface water, when it got injected, the oxygen attached to the iron and the lead and the arsenic, the heavy metals that were naturally found in the clay, and normally are bound to the clay. And when there's no oxygen there, you can pull the groundwater out and you don't get any of those heavy metals. You get very few of the heavy metals found. But the oxygenated water grabbed those heavy metals, and when they pulled the water back out, they were so high in heavy metals, they had to treat that water again before they could use it. So now you've got twice treated water, and it becomes too expensive to have a successful project. In that instance, the contaminant that they introduced into the aquifer was oxygen. Some people don't consider it contamination, but in this case, it was, because the chemical reaction occurred. So it's very important when looking at these aquifer storage and recovery projects, if you're not putting it into areas where there's a potential contamination for any other activities you might be using it as. For example, Henry Gibson, the Mexican livestock grow nearby to that Texas City project, they may have been pulling arsenic and lead up through their wells without knowing. So you have to be very careful about where the injection well is going to occur. Then you also have to be very careful about how much water you're going to allow to be thrown and when. Because if you wait too long, that pressure bubble may dissipate, in which case now it has the same impact as if you're withdrawing native groundwater. So all those things have to be considered. The Bridge of Wilcox has some spots. They're very favorable for aquifer storage and recovery. But generally, it's not going to be true of the entire aquifer. It does lead down dip. There's lots of places to do people plug in. It's just going to go downhill and become part of the main water. And so having people withdraw it later, simply going to interfere with the overall water level that may impact other people. What Representative Gertis has done with this bill is he said that you cannot have, the TCEQ cannot issue a Class 5 injection well permit anywhere within Los Banos district if that application is filed by a certain municipality, in this case, the city of Boston. What it doesn't address is that there are now 3 different ASR projects in the current regional water plan. And, some of those might be in great areas for them and some of them might not. And I don't know enough. And I already get accused way too often of pretending like I'm a hydrogeologist, but I'm not. So I'm not going to say whether those are good ideas or bad ideas. But I think we need to have a strong voice in that process. So I don't know what's going to happen with this bill. If it's going to be limited to that one ASR project, if it's going to be expanded. And I hope that this is an opportunity to try and change the law to allow Groundwater Conservation District back into the process. We're talking about how much can be withdrawn, how quickly you can, and what the timeline is for those withdrawals. But we'll see what happens as the bill goes through the process. In any case, we do appreciate Representative Curtis being very careful with our aquifer, being very mindful of what's going on and filing the bill, and we'll recommend passage in this resolution.
What's the definition of a class 5 injection well?
That's supposed to be something that you're not putting any kind of contaminant into the aquifer. It's basically clean water going into the aquifer.
So they didn't do any preliminary testing, that project you're talking about? They just started the project up without
Well,
checking.
they didn't consider the impact that having oxygenated water going into the aquifer in that location would have. And frankly, because if you draw the water out before you put the oxygenated water in, you're not seeing a lot worse.
Right.
They didn't see it until they actually tried the project, and then they they injected some water, they pulled it back out, and found the problem. That's why you do test wells.
That's right.
Yeah, I believe the groundwater district should be part of the process somewhat. And I would like to see the bill or the law change so that the districts have more of a partnership and part of the process, for sure.
Is there going to be kind of a problem with this because it's confined by, the 70,000, exactly where it is? Is that an issue? Maybe it could be expanded or?
Having those very small right now, because the other projects that are out there. It's his bill, so he'll decide whether he wants to expand it or not, but he's aware of the issue. Right now, it's aimed at just that one project right here. The population figures are frequently used as what they call brackets. And at least every 10 years, the legislation comes go through and they look at those brackets and change them according to whatever the population is. But yes, that would eventually have to be fixed if the population did change.
But it is.
The legislative council looks at those population brackets in law frequently. There'll be a bill filed part of this time that does nothing but change population brackets in a number of bills.
I heard that Williamson County had submitted a similar bill. Is that true? Or is that just gossip?
No, I have seen the similar bill for you.
I move that we adopt the resolution supporting House Bill number 1523.
Second.
Okay, I have a motion to adopt the resolution regarding House Bill 1523 by Director Arsupi and seconded by Director Textor. All those in favor, please say aye. Aye. Any opposed? Hearing none, the motion passes. Thank you, Mr. Ellis. I think that's it in terms of the resolutions. We are now up to item 4G. The committee reports with possible board discussion. No action will be taken. I believe the only committee that met has been the governance committee. We met on January 6th at 9 a.m. via Zoom. It was myself, Director Rogers, and Mr. Mang. In attendance were Natasha Martin, Bobby Saleh, and James Totten. We discussed the Rambo and status. We prepared for the elections. There's an auditor RFP that Mr. Totten will be soon, if he has not yet, will be publishing for an auditor RFQ it is. I still have the RFP from last time. RFQ it is. It looks like I'm planning half to do a database demonstration of our database, which has been updated for February. So if you take a look at our database, you'll now see a lot more data in the wells. And we've got a whole new category of wells, of unregistered wells that are registered with the state, but not with the district. And those have been added. And so I'm looking to get a demonstration for February. Rolling out new email accounts, that'll soon happen, to have set up all the directors with new email accounts on our new email system. Our goal is to update our S19 pumping files in time for the next February GMA 12 meeting. Looks like we should have our updates for the fall 2024 monitoring updates, hopefully for next month. Darling Industries, we spoke about that. I believe Jim will speak about it further in his GM report. And Jim brought up a potential new rule regarding tracking water loss. And that'll be taken up by the committees, the management committee, as appropriate.
Education committee did meet, so Claire has everything.
Okay, that's right. Okay, thank you for that. So Education Committee did meet, so we'll have an update. Oh, and that is in, okay, I do see a hard copy. Everyone should have a hard copy here in front of you.
Howdy, y'all.
Howdy.
All right, so we discussed a groundwater 101 board training. We thought this would be really good to make sure that all the board members are on the same page regarding rules, laws, jurisdiction, all that good stuff. Part one of that, we went over today, which was perfect. We are proposing that part two takes place at the next board meeting, and that would just be groundwater science, like a little overview for everyone. Make sure just we're all on the same page of how groundwater aquifers actually work. We started our photo voice contest. This year's theme is Thank You Well. A photo voice is a mix of photography and then also storytelling. So someone will snap a picture of why they're thankful for their well water, and then they'll have a little write-up with that. I'm hoping that we get enough submissions where we can actually produce a calendar for 2026. And each month we'll have the picture, their narrative that goes along with it, and then we'll also put some water conservation tips scattered throughout.
And this is adults and kids,
Yes.
anybody.
Anyone can apply. Then we have a K through 12 art contest that we just announced. I've been reaching out to different principals at schools. So far, I think we have 4 schools that are on board. This art contest, the theme is Every Drop Counts. So the students can paint, color, draw, what that means to them and how they save water either at home, at school, or in their communities. There will be student prizes, but the incentive for teachers to actually have their students do this is each teacher of a winning student also gets $50 for classroom use. So I'm hoping that helps with us getting a lot of good submissions. Okay, so January 25th, we still have the rainwater harvesting workshop coming up. I'm really excited. We've had 23 participants thus far, which is great. I'm very happy with that number. On January 28th, this is a really exciting opportunity. Me and Nick actually, we're going to be going to Bastrop High School, and we're going to be doing a water conservation workshop with their student council. So we're going to be talking, kind of just an overview of water in general. We're going to help the student council facilitate a water audit of their school. They will actually go through the school and see where water is being used efficiently and inefficiently. And then after that, they're going to come up with a water conservation campaign for their school and what they propose to save water on campus. So I'm really looking forward to this experience. And then February 19th, we are having an open house, finally.
I have a conflict on that.
Oh, no.
Well,
Some
we've
of our
got
board members.
going to San Antonio to the state bar, changing faces of water.
Okay.
that day.
So you won't be there for the board meeting either, I assume. Okay.
We may have to end up,
And
we'll,
neither
we'll
will
discuss it, the
we.
upcoming meetings agenda item, but we may need to change
But
to
you can't
February.
make it without me.
Excuse me? Oh, yeah. It's just that they're gonna be in San Antonio and the lawyers as well.
Would it be appropriate to delay it? Because this is.
Yeah, we could discuss that.
Yeah, we'll discuss it during the upcoming
Okay.
meeting session.
Okay.
Yes.
Perfect. I do want to note for the open house, I'm gonna note this when I'm announcing it on social media and to the newspapers. Since we probably will have a quorum there, I'm hoping all of the board members will be there. It's important that we do not discuss business matters at this open house. If someone brings up, maybe not y'all, but if someone from the public brings that up, we can say, oh, we can't talk about that right now, but here's my email. Or come to our next board meeting and we can discuss this. We cannot discuss any official matters. This is purely just a community event, a learning experience. We're gonna have an edible aquifer there. People are gonna be able to explore our new, what it's called, our digital groundwater model. And then we're gonna have a real life aquifer model there too, where people can play around with that. So this is purely just learning. No business is gonna happen at open. Okay, any questions? Yes.
Okay, the lawyers went through, what districts can do and what they cannot do.
Yes, sir.
That is things that we can share with the public. Correct? That doesn't come under,
Well, I haven't heard the whole agenda, but we'll look at it before we have the open house.
okay? Yeah, people ask us, what do we do?
Oh, right, of course,
Yeah,
that should be
that's what
part of it, yeah,
That's what I'm
let's do
talking
it,
about.
yeah. Oh, I thought you meant like what we were
It's in the
discussing at the,
No.
Yeah,
what
we should
we
do that.
do.
right, oh, of
Okay,
course,
Thanks.
yeah,
And what
Yes.
we don't do.
right.
Yeah.
And also to Bobby's presentation, if a quorum of you plan to attend, we will publish notice. for this.
notice.
We'll just, it's called a notice of quorum.
This event that's
Yep.
after the board meeting? That's the event we're talking about?
She was
Yeah.
planning it for an after board meeting,
Right.
yes.
My-
So we would,
Be here
Yes.
anyway.
right, so we would need
Probably
to
all know
post
that-
another notice though for that.
My thinking of having it after a board meeting was hopefully everyone was already gonna be here. And then also the community members that would probably attend the open house anyways, they're probably gonna already be here for the board meeting, so I thought it would just be easier for us all to have it right after each other. So, but we can discuss that a little later. Okay, anything else? Awesome, thank you.
Thank you. All right. Item 4H, General Manager's Report. No action will be taken. Mr. Toppins.
Thank you, Mr. President, members of the board. The general manager's report is on the dais along with bill tracking reports that Greg Ellis sent over today and the bill tracking report that I put together at the end of last week. So you have those for your references. The reporting period, December 1st through December 31st, we had 8 new wells that were permitted within the district for domestic and agricultural usage. 2 water quality tests were performed and 2 wells were gauged. Drought within the district has eased somewhat. Lee County has seen a fairly decent shift out of severe drought, with 98% of Lee County now being in moderate drought, which is D1. Whereas in December, almost 41% of Lee County was in severe drought. So the most recent rain seemed to have helped ease drought conditions in Lee County. In Bastrop County, the drought conditions haven't really changed from where they were in December. There's been a little bit of movement between severe and moderate drought, but effectively there's no difference there. Overall, for 2024, rainfall in Bastrop County was still almost 2 inches above the average, the long-term average. In Lee County, it was almost 7 inches above the long-term average for 2024. So what we saw was we had very wet spring, and then late summer, the rains turned off, and we're just now starting to see that again. But overall, we did fairly well in terms of drought across the district. GMA 12 is scheduled to meet on the 21st of February at Post Oak Savannah's offices in Milano. That meeting will also be online. We have not set the agenda yet, but I do know that discussions of the AWA Jackson across GMA 12 is going to be part of that meeting. That was brought up by Director Van Dresser from Fayette County. He felt that the AWA Jackson, which is one of their primary formations, have been kind of neglected. So we're going to have some discussion on AWA Jackson. But the meat and potatoes is this will be the first meeting where we really begin discussion towards adopting the preliminary DFC for this planning cycle. The calendar that the GMA had previously adopted, we want to have preliminary DFCs adopted by the end of 2025 to allow districts to have a preliminary hearings in early 2026. With an eye to doing a final adoption of proposed DFCs, which is the actual legally defined term, in May of 2026. This is a deviation from what we've done in the past. In the past, there's been one adoption, one set of hearings, and then the final adoption by the GMA. What we're trying to do this time is get preliminary DFCs back to the districts, get input from the public and stakeholders, bring that back in time to make changes that need to be changed before we make the actual proposed adoption of the proposed DFCs in May. So we're still 18 months out from the proposed DFC deadline, but this will be when we start really getting into the nuts and bolts of trying to adopt those DFCs. So I'll be working with you as a full board and then at the committee level as well as we work through that process. But for right now, the first step is getting the districts together with their pumping files, as Elvis mentioned, and starting to figure out what those pumping files mean for the previously adopted DFCs. And I am not entirely sure why this computer keeps looking for a printer, but I don't think we need that message. So yeah, that's the where we're at with the GMA 12. As Elvis mentioned, we're working to have the pumping file updated in preparation of the February meeting there. One item that I'm going to skip ahead a little bit on my report. One item that does factor into that, one of the discussions we previously had was about modifying the pumping file to rather than including all possible permits, we were possibly looking at taking out permits that may not be in production in the next 5 years. And the hallmark of what I consider good governance, the city of Georgetown had a meeting at 6 p.m. on New Year's Eve and approved a contract with Gatehouse. So the Gatehouse permit now has a buyer. And so we may need to reevaluate whether or not we include that production. Originally, it was talked about taking that out of our pumping file. We still need some details, but it looks like that may be something that needs to remain in for the planning cycle. So I attached to the GM report as a copy of the article, the only article I found that actually covered that contract. So you have that for your reference. We'll continue to get some information and develop that going forward.
Yeah.
Yes, sir.
Isn't that supposed to be, it's not gonna be ready to be pumped until 2030, so that's the next planning cycle, right?
There's no dates on the article that I have.
I've read that or forgot.
Okay. I don't recall seeing a date on there.
How long pipeline, yeah.
They have a lot of work to do, but
Yeah.
If it's under contract, that's.
Yeah, it says they can receive, the treated groundwater by 2030.
It's
They're gonna build that pipeline.
Depends on how motivated they are, I
Yeah,
suppose.
I bet it won't be down.
Yeah.
He's already started clearing the right of ways.
Well.
Yes, sir.
You're right.
Maybe, I don't.
So we'll factor that in as we develop that. But I did want to make you aware that, you know, I think January 3rd was when the news story popped up in my email. And so it didn't seem to be well covered. I wanted to make sure y'all were aware of that.
One other quick question, where are they getting that water from? Refresh my memory.
That's, Simmonsboro Wells up around County Road 410 and
Yeah,
411.
okay, I was wondering if Simmonsboro.
Yes, sir. I mean, extremely deep Simmonsboro wells in that part of the world, but it is Simmonsboro water.
Okay, thank you.
With regard to the overpumping that was, done by, I keep wanting to say Griffin Industries, that's their old name, Darling Ingredients. We have not received their final production report for December. But I'm working with our attorneys on developing a fee structure that will be scalable and appropriate for all of our permit holders in future if the situation arises again. Hopefully I can have that to y'all for consideration at the February board meeting. But I didn't want to start finalizing numbers and coming up with a plan until we knew exactly how much the overage was in this case. But we will hopefully have that for y'all at the February board meeting so we can move that forward.
Well, would we allow somebody to just keep over pumping and pay a penalty? I mean, that's just another way of them getting more water than we wanted to give them.
So that is something that we're trying to address in how we structure this.
Did they see this coming? I mean, is
I
this,
spoke with them, back in November. I spoke with one of their vice presidents to let them know that this was an issue that we were gonna have to address it with them.
but I mean, could they have warned us that they were gonna overpump, or did we just have to discover?
They probably should have, but they did not. And that may be something that we could factor into the
Well, I
structure
think
as
so
well.
too.
Which, you know, we'll look and see if we could add consideration for giving us advance notice of why.
DCQ calls it the good faith credit in their penalty
There you go.
process.
But
Well,
definitely
everybody
one
else
of,
following the rules.
yeah, definitely one of the ideas is, especially for permit holders that are in the business of directly selling water, removing the profit motive for violating their permit. That's definitely something that we want to establish so that our fees, it doesn't matter, you know, double, if you pump double or triple what you're permitted, you make no profit off that. And then a penalty on top of it as well. So that's definitely something we're looking at in developing the structure. Yes, ma'am. It's a little bit harder for people that aren't directly selling water to disambiguate how much money they're making if they're not, you know, if water goes into the product, but it's not the product they're actually selling, it's a little bit harder to structure that, but that's what we're trying to figure out. And like I said, hopefully we'll have that ready for the.
Well, I guess that's what I'm asking. We can ask for a penalty,
Yes, ma'am.
but can we cut them off and certain, what they've been given?
Yeah, that would be a possibility as well, yes, ma'am. And I would say in the more egregious, if, I wouldn't do it if they go over by 1% or, you know, but in more egregious cases, or I would say more likely in cases of repeated violations, then that would definitely be an option.
Yeah, I'm just gonna be.
Yes, ma'am.
Did you do that for public water supply? I didn't think we could do that for CCN.
Be an interesting fight.
I think we're a little outside of our.
Do we need an executive session?
Yeah.
We'll-
We can look at that whenever we have
curious.
the rule. Yeah,
Hopefully we don't ever have to.
I think there's some litigation that would play into this.
Moving on, the district staff consultants are continuing to work with Director Darcy and Hector on the socioeconomic study proposals, including a broad spectrum socioeconomic study that previously been discussed, as well as more specific development of methods for evaluating socioeconomic impacts within the district. If y'all still have time, we'll meet after the meeting to have that discussion. And then have a follow-up meetings with LRE once we kind of have our ducks in a row. With regard to pending permits, we still have amendment application from Aqua seeking to increase production from one of their wells in the S field. SLR is seeking to amend their permits to add new wells with no increase in production, annual production. So this would be like the other permit amendments we've done recently, which is just adding new wells to an existing permit.
Can you mention the location of those wells to be more precise?
They are, trying to remember the county road now.
320?
It's moving closer to the blue area, but it's still,
Just where I live.
yes, ma'am, yeah, it's closer to blue than they currently are.
312, 309.
Something, yeah, I can't recall the exact numbers off the top of my head. Because they're moving between grid cells, we'll have to do some modeling Normally, if it's within a grid cell, it doesn't require any modeling, but we'll have to do that just because they are adding new wells outside of the existing grid cell.
Was this perhaps the depressurization wells from the lignite mine?
These are going to be new wells to help serve the water that they're currently providing to Manville Water Supply. Getting them into a position that's more appropriate for Manville and getting it closer to their collection and distribution system up at Tonka. With regard to upcoming meetings, we have GMA 12 is meeting February 21st. As I mentioned, at the Post Oak Savannah offices. Region K will be having another meeting on GMA is 12 is the 21st. Region K is the 12th, and they'll be at the LCRA Rosebud Center rather than the normal Dalco Service Center. And I believe that concludes my general manager's report. I'd be happy to answer any questions.
Thank you, Jim. Item 4I, consideration of future agenda items. Again, I'm working with HAF. There's a good chance we're gonna have the HAF do a quick database demo to show us all their updates. We might have missed a bill from Mr. Curtis, two bills from Representative Curtis, so that will,
Well, one is.
one is called Curtis. Okay, the mirrored bills, but I believe we missed one of the Curtis bills, Curtis groundwater bills, and that will be taken up in February. As mentioned by Claire, aquifer training possibly, and also the penalties. Jim just mentioned he's working up some, drafting up some penalties. And in February, I will probably also announce any changes, if there are changes to the committees. And if, I'll probably work with folks to see if folks want to change committees, or not.
One other thing, we had dropped the legislative update off because we're out of session. We probably need to add the legislative update back onto the agenda.
Well, that's the one that we always had carried
Yes,
over,
yeah.
and we always had on the, okay.
As soon as Greg sat down, I scanned the rest of the agenda and realized we didn't have an item for him to stand back up, so.
Yeah, we typically have a placeholder item that we keep in the agenda regarding, like, okay, so we'll add that back. Okay.
I'm sure you all have broken hearts now. But you can always call me with questions.
Lois, when did we say we were gonna talk about whether to have open house on the 19th of the month?
Next item. So that's it regarding future agenda. Anybody else with future agenda items? Not, we'll move. No, I'll get them. I'm sure they're in that list, or plus I believe I have it.
They are.
So now we'll move on to item 4J, discussion, consideration, and possible action on district board meeting calendar. Anything about the calendar we need to discuss? I guess the main thing is really the next meeting date. It's typically, we would have had the meeting on February 19th, which is the third Wednesday. I'm being told that there's a conflict with a water conference in San.
Well, it's only if you want to go to San Antonio. The meeting starts the next morning at 8 o'clock.
Oh, the meeting starts the next morning.
Yeah,
Okay.
but I'm not gonna drive to San Antonio after dark. The night before.
Right, but
so-
there is a possibility maybe you could do it online, possibly, remotely?
No, it's a conference. You go
No,
to-
no, but the conference is,
Oh, yeah, I could probably do that.
yeah, but
We will.
our legal counsel will be gone too, so.
If we can attend remotely, that
With the,
might work.
with the 26th, if we push it back a week, would that work?
Oh, 12. Is that too soon?
That's a pretty quick turnaround.
Yeah, it is.
How about the 18th?
I mean,
I've got a 6 o'clock meeting, but that's okay.
There is.
So options are to move it 1 week earlier, 1 week later. I guess the 1 week later, someone had a conflict with the 26th.
Cheryl's not
Cheryl,
gonna be
you have a
here.
conflict with the 26th. Is that the only conflict for the 26th?
I'll be on a boat.
Oh, you'll be on a boat, so, oh, the golf, okay, I guess. No options there.
How about 18th or 25th?
Yeah, the 18th,
Cheryl will probably be on that boat then.
18th or the 25th?
Are you gonna be on the
18th,
boat?
I
the
have a 6
25th?
o'clock, 6 to 7, but I might be able to miss it. I
But
could,
you
yeah, I
just
could
be open
possibly
house.
miss that one. It's a Zoom call.
Because we are looking at having an open house afterwards too.
Yeah, no, I could probably do that and just miss that Zoom call. It's not, just nothing, Zoom. I could just say,
So the 18th?
We're on a board meeting that day.
Okay.
We're busy people.
25th,
What?
Tuesday, the 25th?
How about the boat,
Right.
Cheryl?
That's great, the 25th.
You won't be on the
25th?
boat? Yes.
No, not, we're driving, yeah, we're actually not driving. Boat's the 27th, but we'll be driving on the 26th.
25, folks?
So it'll be a Tuesday meeting?
Tuesday meeting?
Okay.
Tuesday, the 25th?
Is that okay?
Claire, is that good for you for open house?
That would be the open house afterwards,
The 25th, the
25th,
53rd?
Tuesday.
You get 6 extra days.
I need him to check his calendar. Joe,
Okay.
check your calendar for the 25th.
Well, it's
We don't
okay. It's on Mondays now. Her probably in Austin that day. I
So
see it.
there's just so much-
Good, okay. All right, so Tuesday, the 25th, 3:30 PM here in Giddings will be the next meeting. And we will plan on having a open house after the board meeting ends on the 25th of February, Tuesday. So that is the date and location of the next meeting. Anything else?
Can we use the open house to hold the agenda hostage and make sure it's short?
We'll see.
Doesn't sound like it's gonna be short, I'm ready.
Can we use the open house to have, like a little food after the meeting?
Yeah, I think there will be, the plan is to have some refreshments for the open house. All right, with that, I will adjourn. Today's meeting is adjourned at 4:42 PM. Thank you.